What They Don't Tell You brings you real conversations about wealth management that real people have behind closed doors. We bring together clients and experts to talk about topics that go beyond the numbers. In this episode, we discuss estate planning, an uncomfortable topic that many would rather avoid, but is crucial in planning for your future, regardless of the stage of life you find yourself in. Lawyer Ailsa McGurk shares what they don't tell you about the practical realities of estate planning, from preparing for the difficult conversations to navigating holographic wills and will kits and choosing an executor.
Hello, everyone. My name is Anna Premyslova, investment advisor here at CWB McLean Partners. And on today's episode of What They Don't Tell You, brought to you digitally at a safe social distance, I have Ailsa McGurk, wills and estate lawyer at Underwood Gilhome. And today we are covering a topic that's a little uncomfortable, that might make folks squirm in their seats a little bit, but is ever important, perhaps now more so than ever. So Ailsa, thank you so much for joining me.
Thanks for having me, Anna.
Wonderful. So Ailsa, to introduce everyone to yourself, I'd just like to ask a little bit about your background, because I know that you came into the law profession in a bit of an unconventional way, and you actually already had a successful career in the health sciences sector prior to becoming a lawyer. So can you tell me a little bit more about the why behind that and how that past experience informs your law practice now?
Yeah, well, I was actually an occupational therapist for many years in the health services prior to going into law. And while I was working as an occupational therapist, I focused my practice then on working with clients who had conditions like strokes or brain injuries, or had injuries and illness and required assistance in the community during hospital. And what I saw while I was working with those clients was the practical realities of when somebody does not have the estate planning documents or the incapacity planning documents in place. And I also saw when people left their decision making around such things as wills until the last minute. And so I have examples of having to help clients get carried out of their house in order to get to see a lawyer to do their will, rather than having done that, many years before when they weren't in that condition. So when I decided to make a career change, I decided that I really wanted to help people plan and put things in place so that they didn't have to go through the things that I saw some of my clients go through. And I really wanted to make the estate planning process comfortable and allow clients the opportunity to learn about this process and the things that need to go in this so that they could make good decisions and feel good about their plan moving forward. Most people don't enjoy the thought of what's going to happen when they're gone, right? Or thinking about that. And I think it's maybe we should reframe the question as rather thinking about what's going to happen when I die, as opposed to how do I create a legacy and how do I ensure that my loved ones are cared for? And I think by flipping the question, it can be a much more comfortable and less scary experience.
And I think now more than ever, we're reminded that no one is too healthy or too preoccupied or too young or too anything to really think about what's going to happen, when that time does come, and hopefully it's a long ways away. Do you see people being more mindful, more conscious about their estate planning, or are folks maybe running the opposite direction?
To be honest, there's been a mix. Some people are really panicking and wanting to get things done sort of in a rush, and other people I think are still kind of a bit in shock and waiting to do their planning. But I think what we have seen is a conversation shift to what are the practicalities around these documents and their uses, right? So whereas before someone may have made a decision with regards to their choice of executor, for example, and chosen all 4 of their children who live in different provinces, now we're able to see what the practical ramifications of that would be in a situation like COVID, where those 4 people can't get out to do the job that they've been tasked to do. So it's brought it really down to a very practical conversation level.
Yep. And so, as you've mentioned, this really has given folks the opportunity to start preparing in a more practical sense. So maybe let's start a conversation there around what it takes to prepare to get into the estate planning process. So as you and I have been chatting about this over the past couple of weeks, We've talked about the fact that, some folks come to you really unprepared and they're overwhelmed. Sometimes there's emotions, there's tears when folks come into your office. And that's, nothing abnormal about that. But some folks come into it saying, hey, you know what? That wasn't as terrible as I actually thought. So, in your experience, what makes the difference between folks that fall into the latter camp versus the first?
Part of it's preparation for sure. So, and part of it's personality too, right? So, I have clients who are generally very organized in their life. So, they have thought through things like what their assets are and all their relatives and all those types of things and bring me lists. But I think the people who have the really emotional responses to estate planning maybe aren't quite aware that as part of the estate planning process, it's my job to go beyond just them saying, I want to give this to so and so. In order for me to ensure that their intentions are going to be able to be honored, I need to ask questions about, who is their family and what family members do they owe maybe a legal responsibility to care for. What are their assets? I need to know that they know what their value of the assets are and where they're located, how they're held. I need to know things like, do they have support obligations to children or partners that maybe they're separated or divorced from. So there's certain questions that sometimes catch people off guard. They didn't realize that I would be needing to get that information. But if they have the ability to prepare for that and they know that it's a broad conversation in order to do a good estate plan, people usually leave smiling with a sigh of relief rather than with tears.
Yeah, yeah, and that's always the goal, I'm assuming. So Ailsa, as you said, you often do have to ask some really uncomfortable questions and perhaps questions that folks prickle at or wouldn't expect to have you ask on a first meeting, first time they walk into your office. Things about blended families, past marriages, histories of illness, things of that nature. So what do you find that folks are most surprised to hear you ask about? And what kind of documents or what kind of knowledge should they come prepared with to keep themselves from, facing that uncomfortable seat shifting conversation?
Absolutely. I think probably the biggest thing that actually shocks most people is that I actually, again, need to know what their assets are, right? So I need them to be able to demonstrate a knowledge of, do they own real estate? Do they own investments? What are their bank accounts? And what, generally speaking, what the values are of those things. I have a lot of people who sort of pause and say, well, why do you need to know that? And the response to that is, it's part of the legal test for capacity that people can demonstrate that they know what they own so that they can then legally give that away through their estate planning documents.
So maybe give their investment advisor a call before they come to see you.
Absolutely. Very helpful when they arrive with a list of their investments and values and such.
Perfect, perfect. And so when folks do come into your office, we sometimes hear about this three pillars of estate planning or the trifecta of estate planning. So what should folks be expecting to discuss? What kind of documents will you help them with when they come to you?
Yeah. So I think, again, a lot of people are maybe surprised that it's not just the will, right? So when we're talking about estate planning, we're usually talking about three separate documents. The first, obviously, being the will. But then there's also two documents that are used when you're alive, but you can't make decisions for yourself. And that is the personal directive, which is the healthcare directive for when you can't make personal decisions for yourself. And the other is the enduring power of attorney, which is where you would use that if you were unable to make decisions for yourself about your finances or your property.
So Ailsa, let's say that someone feels particularly inspired by hearing our conversation today and decides to take the first step towards their estate planning journey. Practically speaking, how should someone go about looking for an estate lawyer, an estate professional to help them with this?
Yeah, well, I would imagine that, most people would maybe ask their friends who've gone through an estate planning process for recommendation. There's always, Google. People would be Googling estate planning lawyers. And if that's the route that people have chosen, I would suggest that they look for an estate planning lawyer that focuses on estate planning or it's a large part of their practice. I would also suggest that if you're working with an investment professional, that that person probably knows you, has a good idea of your personality, and also probably has connections with the estate planning community, and can make recommendations to good estate planning lawyers out there.
Well, unsurprisingly, Ailsa, I love that last recommendation. I think, any good financial advisor really prides themselves on knowing not only the financial situation of their clients, but also their personalities. And like you're saying, especially for a situation like this and a topic like this that's a little uncomfortable, it might make good sense to find someone who's not just competent and great at their jobs, but also will be a fit for you personality-wise. So just like investing, I think it's important to mention the fact that some folks choose to do their estate planning on their own. And especially in a province like Alberta, where holograph wills are accepted by the courts, that might seem like an even more tempting option to someone. So Ailsa, could you first please elaborate for us on what exactly a holograph will is, how one is used, and maybe some of the challenges with it that folks don't realize before they get down that path?
Absolutely. So there's two ways of making a will, essentially. One is what people are familiar with, what we call a formal will, which is, typed up. It's done usually by a lawyer, and then it's signed and witnessed by two witnesses. Um, the other way that people can do a will is the holograph will. And what that means is that a holograph will is a will where somebody does the entire thing in their own handwriting. They sign and they date it, and there's no witnesses required for that. So you can imagine in an emergency situation that could be a useful way to go about doing a will. And the concrete example of that was a case in Saskatchewan in 1948 where a farmer was trapped under a tractor for many hours, knew that this was not a good situation, and he managed to actually carve into the bumper of his truck a will of sorts. And so when he actually passed away, the family found that bumper, and were able to convince the court that this was his will. The challenges with a holograph will are that, first of all, there's nobody there who's going to be asking you the tough questions. So there may not be the components in there that you're actually going to need. So you may not have put in things about trusts for minor children, or guardians for those minor children. You may not have realized that you have support obligations, or that you have to provide for certain family members through your will. As well, the holograph will isn't always useful in other jurisdictions. So while we recognize it here in Alberta, and there's some other provinces in Canada that recognize it, there's also other provinces that don't necessarily recognize a holograph will. Or if you have property outside of the country, for instance, I can't guarantee that your holograph will would be recognized to deal with your property there. And finally, with a holograph will, yes, it's convenient in the sense that you can do it on your own at home and you don't need witnesses. But at the end of the day, when your executor goes to try and use that will and manage your estate, they still need to go through an extra process to prove that that was your handwriting. So they have to find somebody who's willing to swear that was your handwriting. So any convenience that you might have saved on one side may be outweighed by the complications it could cause when that document needs to be used.
So what I've deduced from your explanation, Ailsa, is that maybe holograph wills aren't as easy and cost effective as some folks would actually assume. But what about estate kits? Those seem to come with legitimate instructions. I'm sure we've all seen them around, and they seem to do a better job of helping you DIY your own estate plan. So as a professional in the field, have you come across those, and what are your opinions on them?
Yeah, so absolutely. We've probably all seen those in either the registries or the bookshops, right? And they're an effort to provide some instructions in an effort to help people make a formal will, right? So that's the will that requires two witness signatures and a date. You know, there's pros and cons with that as well, right? Some of the challenges with a will kit are that maybe you bought it, and at the time you bought it, it was up to date in terms of the legislation. But the reality is that most of these kits sit around and they don't get used for many, many years. So by the time somebody gets around to maybe trying to use it, it could be that the information in there is out of date. The other things are, it's really, you have to follow the instructions, right? So you have to follow the instructions so that they meet the requirements of a formal will. And if you're the type of person that doesn't enjoy recipes or can't follow IKEA furniture making instructions, it's probably not the best choice for you, because if the will isn't done as per the instructions, at the end of the day, your executor is still going to have to do extra steps in order to be able to use that will.
Well, that's all I needed to hear. If following an estate kit is anything like IKEA instructions, I know I would need some professional help. But Ailsa, let's talk about the folks that don't do an estate kit, that don't do a holograph will, and for whatever reason don't use a professional estate lawyer either. Let's address maybe what exactly does happen if you were to pass away without a will at all.
Yeah, so that's a great question, Anna. I guess I could start by saying, the choice to not do a will, you are actually choosing to make a will, but this time it's the government that's making that will for you. And they're doing that through the rules that they have through what we call the Wills and Succession Act in Alberta. And in that legislation, it actually lays out who would inherit your property and your assets if you didn't make your own will. And so first and foremost, it's only going to go to family members. So there's no room for, provision for your best friend or your favorite charity. Okay. Also, if you're a single person and you don't have a spouse or a common law spouse and there's no children, the first place it's going to go is parents if they're alive. If they're not alive, then it's going to go to siblings, and then down the line to nieces and nephews, etc. If you have a more complicated situation, you've got a spouse or a common law spouse, you've got children, well then it's maybe all going to the spouse. It might have to be shared between spouse and children, but it is going to stay within the family and the next of kin. So if you think about your family and there's people in there that you really wouldn't want to have access or inherit any of your property, it's maybe a good idea to get some different wishes and intentions down on paper.
And Ailsa, a second ago, you mentioned something that I think probably piqued a few folks' attention. You mentioned assets in other jurisdictions. So say that I've got a condo in Arizona, or maybe even just a little property out in BC. What happens if something like that is in my will? Is that going to cause me any road bumps as I get down?
It certainly could. So when we're dealing with estate planning, so if you do a will in Alberta, for instance, that will cover your property that you own in Alberta, right? And then your bank accounts and investments, things like that. But should you own that condo in BC, your will now needs to go to BC to go through the process of probate in BC. And so the will that you created in Alberta will have to then go to a court in BC to be determined that it's valid, and then move forward with managing that property in that jurisdiction. Now, if you're a person who has multiple properties, real estate is what we're talking about usually, especially if you've got them outside of the country, my recommendation is always to go and see an estate planning lawyer in that jurisdiction and actually have documents drawn up, so an enduring power of attorney or the equivalent, and a will in that jurisdiction, which only deals with that property. And so what that does is that when those documents have to be used, nobody has to prove that they meet the requirements of that jurisdiction because the documents were drawn up there.
Mm-hmm. And why is it so important to have a professional make sure that they are making a will specifically for that property? Can you ever encounter issues with competing wills like that?
Absolutely. So when you have any of these other documents for other jurisdictions, it's super important that if I've prepared a will for somebody, say for the majority of their property in Alberta, I don't want them to go to Arizona and have the Arizona estate lawyer do a document that revokes or gets rid of the will that I've prepared for them in Alberta. So it's really important that the person that they see understands how to word things so that it doesn't affect the documents that we've done for the majority of their property.
Wow, that would certainly be a situation to get yourself into. So now that we've discussed how to prepare for the estate planning process and the different types of ways that you can get about doing that exercise, let's talk about some of the roles that come into the estate plan. So to start folks off, to get our definitions right off the bat, can you tell us what exactly an executor is to a will?
Absolutely. So the executor is the person that you're going to nominate in your will. They're going to look after your property. So essentially, when someone passes away, the executor is tasked with figuring out everything that you own, right? Protecting it. And then they're legally obligated to deal with that property. So whether that means selling it or maintaining it in the form that it's in, they need to pay all the debts. They need to pay taxes. They need to then deal with any gifts to the beneficiaries, right? So it is a very big job. They also are the ones who are legally responsible for organizing and determining the funeral and how a body is dealt with. So they have a very big role. It's not an honor to be an executor. It's definitely not something that you want to spring on somebody because it can last a long time to act as an executor. And it is a very big job.
Now, don't get me wrong, Ailsa, it certainly sounds like no small feat that this person is undertaking, but when you lay it out like that, it sounds fairly straightforward, in the grand scheme of things. So given that, why do you think there is so much anxiety and discomfort that folks face around the issue of whom it is that they should pick as their executor?
Yeah, that's a big decision that a lot of people agonize over is who should we name? And I think really one of the big things that people should consider is where are the people that I'm possibly looking at naming? And usually if they're in the same jurisdiction as you, that's better. You don't want to name anybody who is outside of the country. And that's just because there could be tax consequences because of that. You really want to think about the person that you're naming. Do they have things like good organizational skills? Are they able to manage money well? Are they able to deal with maybe beneficiaries who are a little bit more difficult to deal with, maybe because they're grieving, right, in a different way? So you need to really think through what the personality is and the traits that this person has in order to pick a good executor.
So it sounds like there's certainly some practical considerations like location, like their skills with, details and numbers and things like that, and a few qualitative ones, personality, things of that nature. But sometimes, and I'm sure you'll agree, that folks, in the effort of protecting the feelings of their loved ones, can make some maybe difficult decisions around executorship that actually cause more issues and more pain down the line, like naming all of their children or naming multiple folks and giving them equal rights over the role. So can you talk to us a little bit about those kind of decisions that people make and why perhaps making the decision up front and making it nice and clear and simple is really the best way to go?
Absolutely. So that is actually one of the common questions that people have, right? Is, oh, I've got four adult children. I don't want anybody to feel left out, so I'm going to name them all as my executors. And so, while that might be an easy thing from this perspective to do, the practical reality of that is if none of those kids live in the same place, they now need to get together to act, and make decisions as executors. Have you had a really good long think about, do these people get along? Can they make decisions together? Or is there a history of, conflict between them? And really, I mean, it is a lot easier if one person is designated as the executor. Sometimes two people is okay. But really what I like to tell clients is, if you don't make that difficult decision now, that's your decision, if there's problems after you pass away, there's no way to tell everybody what your thoughts were, right? And so then it becomes their problem to work out amongst them. So my recommendation is always that you make that difficult decision. And if you do choose, you can name one child and then another as an alternate, and so on and so forth. But if you feel comfortable with it, then share with your family. These are the people that I've chosen as executor, and these are the reasons why. It's not because I didn't trust you and I don't love you. It's for these practical reasons. And that usually helps to diffuse a lot of those emotions around being named as executor.
So I love the advice that you're giving about not putting off the difficult decisions, because the choice really is either I can make that hard decision now, or I can push it off to a later date where my grieving family members or my children are going to have to make that choice for me. And so I've heard you in the past describe your role in all of this as a peacemaker for the generations. And I really like that. And so I wonder if you could expand a little bit more about how you see yourself filling that role as an estate lawyer.
Yeah, so I really see my role as trying to help clients make those tough decisions and put a plan into place so that when they pass away or when somebody starts to make decisions for them, um, they have done all the hard work. So the person who has to step into the role, either as executor or under those incapacity planning documents, they don't need to guess what it was that your intentions were. You've made those hard decisions, you've put things down on paper, and they can just follow your wishes, right? And try to honor your wishes. And that, I think, makes it much easier in terms of the relationships between the people that perhaps you're leaving behind.
I really like that outlook because, in our own lives, we're always so adamant about having our voices be heard. And it's silly that sometimes folks say, well, that's all fine and good, but when the time comes, someone else can make those decisions. So it's a great way to make sure that your intentions are very clear. And like you said, there's no guessing involved as to what exactly you meant and wanted. So Ailsa, as we kind of close out our conversation, wrap up on this important topic, I want to touch on one more thing, and maybe it harkens back to the introduction that we started with. And that's a key misconception among folks that estate planning doesn't apply to them. I think that we all go through stages in our life where first we think we're too young for estate planning.
Hmm.
Then we think that we don't really have any important assets that are worth an estate plan for. Then we say, okay, well, I've got the assets, but you know what? I'm healthy, I'm busy with my career, and I just don't have time for that right now. And finally, you say to yourself, look, okay, I've got the assets and I've got the time, but my family knows me, they understand my wishes. Do I really need to go through all of this hoopla to get all that done? So maybe starting at the beginning, what would you say to a young person that might be thinking, okay, this conversation was great and informative, but it really doesn't apply to me?
Yeah, so I mean, just drawing back on what you mentioned at the beginning of our conversation, Anna, I think this coronavirus pandemic has really uh, brought to all of our attention that we really just don't know, right, what's going to happen. And so yes, I could be super healthy and think that I'm going to be around for a really long time, but I just don't know. And so what I would say is once you're an adult, so in Alberta that's 18, um, it's really important that you have these documents in place, because once you are an adult, mom and dad can't just step in and manage things for you, your bank accounts, your assets, make long-term healthcare decisions for you just because they're mom and dad. There has to be somebody who is in a legal position of authority in order to make those decisions. And the best way to do that, where you get the opportunity to choose that person, is to have those documents in place.
And you were telling us, Ailsa, that as much as it might sound a little bit morbid, in some cases, clients will actually purchase as a gift for their young adults at the starts of their careers, their starts their adulthood. It doesn't have to be anything too complex, but a simple version of an estate plan. Why is that a good idea? What kind of situations might folks be faced with where that really comes in handy?
Absolutely. So I do have had clients who have done that. You go off to university and you're in a different country or you're in a different jurisdiction. You're an adult, and you go off and do something super fun on a trip and get injured, right? If you don't have those incapacity documents that we talked about earlier in place, well, then who has the ability to make decisions for you or decide on your health care or those types of things? So um, it is a really good idea to have those documents in a place. And if you let them sit and you forget about them for a while, that's okay. They're there if you need them.
Well, there you go, everyone. Christmas 2020. And Ailsa, as we look beyond that, as our lives move further, what kind of other milestones can folks be on the lookout for? I know that in your world, estate planning is probably always on your mind, but for the rest of us, if you can give us some markers, some important flags that perhaps should remind us to either start that process if we haven't, or to renew things, to refresh things as time goes on.
Absolutely. So it's always a good idea to check your estate plan or review it. Obviously, when you're an adult, you turn 18. If you acquire real estate or you acquire sizable assets or new assets, as well, if major transitions in life, so things like if you get married or you start living with someone, if you have children, if you get divorced, if you have grandchildren come into the picture. So those sort of major life-changing events are ones where they should give you an opportunity to pause and review your plan, your estate plan.
Wonderful. Well, thank you for everything that we've covered today. We went through the steps of preparing to begin estate planning, the types of estate planning you can embark on, the roles that your estate plan can lay out for people once you've passed, how important it is to think about this all throughout your life, not just as you get later on in the years. And I think this would be a great opportunity for me to ask one more time, Ailsa, what is it that they don't tell you about estate planning? The last thought that you'd like to leave us with on this topic.
I think they don't tell you that the estate plan is more of a gift for the people that you're leaving behind. So the more hard work that you can do upfront and now, people are going to be left with their memories of you rather than of any chaos or the mess that might have been left behind.
Well, thank you, Ailsa, and thank you to everyone listening or watching today to the second episode of What They Don't Tell You. If this has encouraged you to update or to create your estate plan, please reach out to CWB Wealth Management and start the conversation. You'd be surprised how front and center this might be in your conversations with your financial advisor. The first step could be something as simple as just deciding who the beneficiaries are on your registered accounts. It doesn't have to be anything big or scary. Our client portfolio managers and our entire wealth advisory team will be happy to ascertain your entire wealth picture and engage other professionals like Ailsa to round out your financial plan from every angle.